Wow, Sandra, that's wild. Um, all right, we will go ahead and get started. So first of all, I just want to thank all of you for being here, taking time out of your, what day is this? Wednesday evening. And for those of you that have taken the bar exam previously that took February, I'm sorry that you're here, but we are hopeful that you will feel a little bit better after this evening, knowing what to do. And again, if any of you haven't set up a time to go over your exam results with us, or if you have questions about anything, feel free to reach out to us to set that up. We are happy to do a session where we go over your scores with you, look at your essays, look at your PT, talk to you about your MBE percentiles. So I'm Maureen. A lot of you I have maybe spoken with or messaged with on Facebook a little bit. And I am the owner of Bar MD. And along with me, if you guys want to say hi really quickly and introduce yourselves, though I didn't tell you in advance you'd be doing this, hopefully you're okay with it. I have Kate, who has been with me for a number of years, and I have known for longer than she's worked with me and worked with previously at law schools. So she can say hi. And then we also have Becky, who is here, who is, I think, my first employee. And I'm so grateful. So yeah, if you guys want to say hi real quick, go ahead. Kate, if you want to go first.
Hello, real quick. My name's Kate, and I have known Maureen a really long time now, and I have been teaching in law schools and working on the bar exam for almost a decade now. So I'm really happy to be here. And it's nice to meet you, all of you.
Thanks. And I'm Becky or Rebecca. My email's Rebecca, so it's just easier for you to call me that, but I do go by Becky. And as Maureen said, I started with Bar MD right at the beginning, not quite at the very beginning, but a couple cycles in, and have taught and met with students to do a lot of one-on-one support and grading. So I enjoy doing this. I find it always interesting. My brain is always working, just like yours is. So thanks for coming tonight. And I look forward to working and meeting all of you.
All right. And I hope my brain is working tonight. We'll find out though, because this is being recorded and it'll be posted later and all of that. So, all right, I'm going to go ahead and start sharing screen. So what we're going to do is Kate, Becky, and I each took a few of the essays. We each took a few of them and, broke them down, but I'm going to start us off here by just giving you a little bit of some breakdown of info. So just to, go cover what we're going to talk about today. We're really focused on the written component of the exam. We're really focused. That's what we're going to spend the bulk of our time talking about. But by the end of the day, hopefully you'll understand the scoring for the February 2022 bar, the issues in the bar essays, and also the PT. And this PT was honestly a little bit brutal. I've seen some, so we'll get into that at the end. We aren't really talking about MBEs today, but Kate, who you all met, a minute ago, Kate and I will be doing an MBE workshop, we think next week. So be on the lookout for that. I asked in the Facebook group if any of you all are in there about what people are looking for help with more. And so Kate and I we're putting together a special free workshop for that soon. So we don't cover that tonight, but we will cover that in about a week. All right, so talking about our first objective here, the grading. So just a little quick refresher, how bar graders were great. I'm sure a lot of you do know this, but just as a reminder, bar graders spend 2 to 3 minutes on each essay, and it's really probably closer to the 2-minute mark. They really don't dig into your material to figure out whether you've done something correctly. So you really have to give them the material how they want it, organize it well, use the facts where they're supposed to, have counter arguments where they're supposed to be. They're really looking for keywords and solid, thorough analysis. It's really that is absolutely imperative. They really don't look twice. You have to make everything incredibly explicit for them. And I think really the big thing, I think a lot of people are good at issue spotting. It's really that depth of analysis. That's how you really push your score from a 60 to a 65 usually. It's really using every single fact in the fact pattern. So if you weren't pleased with your essay scores, that's something you should really look at in your own essays that you've written. And it's something that we emphasize in our essay course and in our grading. So just a little refresher on that. So the score needed to pass on each written event was a 62.781. So that means on every, in order to get a 1390, you really needed to get a 60, mostly 65s. You really needed to get mostly 65s. And the total raw written score that was needed to get to a 1390 was approximately 440 points. The big thing here that I want to emphasize, is for the July 2021, the prior exam administration, it was actually about a 60, I think it was like a 60.5 or 60.4 that you needed, which meant the total raw written score you needed to hit a 1390 was about 420 points. So it's a big, like the raw score you really needed to do better on the written one here to get a 1390. You had to score a little bit higher on each written event. So for those of you that are feeling discouraged, if your score didn't seem like it moved all that much, despite we know you all put in a lot of work, and if it didn't seem to budge a whole lot, this can help explain it. So I would encourage you all to look at your raw score from this, and not just your scaled score. Look at your raw written score, which below the numbers, there's like three things. There's your total raw score, then total scaled written, total scaled MBE. I would encourage you to look at the raw to see what your raw score was and compare that to your past numbers. But this was a beast. It was really brutal. It's not, Brian asked whether it's usually higher on the February exams in comparison to the July. No, not really. There is always a little bit of movement. But this one I just noticed was particularly higher. I don't know, Kate, do you have anything to comment on that? I meant to tell you I was going to ask you that.
Yeah, usually, I mean, it's not unusual for it to vary, 1.5 to 2 points. I do think this was more than 2 points, which is higher than I would have expected it to be, but I don't think it's anything super crazy. And I don't particularly think that I can look back and maybe we can update in a newsletter. I don't think historically it's been this big of a swing on February, but everything is scaled to the MBE.
Yeah.
So
yeah. And as we know, the MBE scores were down. The MBE scores were down overall. So the reason I bring this up too is because I'm not saying that this, Lucine, I don't think that that's why. But the thing that I will say is, I just lost my train of thought. The thing that I will say is, I know some bar companies say like, oh, you really just need to push for a 60 and that 60s are going to be okay. Like, at least initially when the cut score in October 2020, when it was dropped from a 1440 to a 1390, some companies said, oh, you really just need to get 60s now. You don't necessarily need to get 65s. This really shows that you do need to push for those 65s. So it's not, you really have to push and practice. And this means you really have to deepen your analysis and use every single fact. So that's really that was my big takeaway. Not that that's changed from before, but there really just needs to be a, oh, sorry, can everybody?
All right, let's see
mute?
this.
Let's see. Thanks, Namali. So that was a big takeaway that I had, and I just hope, one thing I want you all to know that, and hopefully it'll, not be this way in July, but we want to really push you and prepare you to be able to really write tons and tons of 65s and strongly be able to do that. All right. We'll get to some of these questions at the end. We'll talk about some of these because for some people that can't stay the whole time, I want to get through the essays. And then we'll go on from there. So now, hopefully you've all reviewed the essays. We sent out that email earlier asking everybody to make sure that you've reviewed it. We're going to cover the issues that were tested and what did you really need to hit? What were the heavy hitter issues based on our review of the fact pattern. So the first essay was that criminal law and procedure. Criminal law and procedure is categorized as one subject, but we all know it's two, but this one did have both subjects in it. So you had Calls 1 and 2 dealt with just criminal law, and the third call dealt with criminal procedure. So I'm going to talk about each in turn. So this was the long-awaited murder hypo that we've been waiting for. They hadn't done murder in like 20 years, homicide. And this one was really a heavy felony murder fact pattern. That's really what the focus was on. And high scoring essays really focus on that. But first, let's just walk through each of the crimes. So there wasn't a whole lot of facts about this, but there was definitely a conspiracy because 2 people had planned to carry out a crime. They had conspired to commit a robbery. Inherent with the conspiracy is that there was potentially a solicitation. One person probably said to the other. So there was a solicitation as well. So there was, but not many people I saw address that, but some really high scoring answers definitely talked about that. And I saw some really high scores in criminal law. So the conspiracy was to commit a robbery. So you needed to discuss the robbery as well. The robbery also served as the basis for the felony murder. So you needed to do, ideally, you would have talked about the conspiracy, then the robbery, and then gone into the murder charges. But you also could have talked about, I don't think they were necessary, but you also could have talked about a larceny, which what we generally think about as a tort, but there is also criminal larceny, also burglary. The modern rule does not require the burglary to be done on a dwelling, although the common law rule does. But under modern law, you could have analyzed this as a burglary as well. You could have also talked about this as an assault, which of course would have merged into the robbery. But you also could have mentioned assault. Some really high scoring answers I saw did do that. But I don't think it was necessary. I saw some that were like 65s that didn't talk about that. And they didn't talk about, they might have mentioned conspiracy, robbery, burglary, but they didn't talk about all of the issues, all of those little additional issues. The big issues, which is what I put the asterisk on here, was the murder of Chris. The murder of Chris, which was the clerk at the store. And this would have been done through felony murder. Really high scoring answers would have done a full-blown and did do a full-blown murder analysis, running through the various types of malice aforethought and causation. But it was really, the fact pattern was pretty obviously a felony murder. So you needed to go into that. Then the murder of Fred. So this was a wrinkle with felony murder, which is liability for the death of a co-felon. So you could talk about that. There is a jurisdictional split here. I think it's the majority says that you're not responsible for the death of a co-felon, which, we can get into a debate about, the ethics and all that behind that. But you had to really differentiate and go heavy into the murder of Chris and into the murder of Fred. Call 2 was for Jim's crimes at Park Street. And this was really just attempted murder. This was attempted murder. So you had to talk about an attempt. There was a substantial step, et cetera. You could also talk about, there are minority approaches to attempt. You could talk about those, but you really need to focus on the majority there. So it was really on the attempt. And there was an attempted murder there because he shot the gun, I think it just missed. So call 1 was really big. Call 2 was, not as big. A few people talked about other crimes. A few people I saw talked about like obstruction of justice, eliminating a witness, stuff like that. Not generally necessary, but, I still saw those issues somewhat regularly. And I don't know if it's because we've seen those issues in the news a bit, in the last few years. So maybe it's just a little bit more fresh in people's minds, but it wasn't necessary. Really, the big thing here was attempt. Then we, of course, had, under the 4th Amendment, can Jim successfully move to suppress his gun? So here you really had to go through, I saw a lot of people just jump straight to a Terry stop. You don't want to do that. You have to follow the whole 4th Amendment protocol. So it's, 4th Amendment, what do you get there? Was there government action? Did you have a reasonable expectation of privacy or standing? You can use those terms interchangeably. To have standing, you must have had a reasonable expectation of privacy in the place your things searched. So was there a reasonable expectation of privacy? He was pulled over. So and you can use Terry stop for the pullover and for the pat down. So you could talk, so for the exceptions to the warrant requirement, the things that people generally talked about was, so a Terry stop, that was the big issue here. Terry stop, and then also really going through, because there was, he pulled over based on the way he was driving. And then also it was fairly obvious that he had a gun, and it was patently apparent. So that's why a lot of people talked about plain view, because it looked as though he had a gun on him. It looked as though he had a gun. So then the officer did a pat down. So you would talk about both of those exceptions. Definitely needed to talk about the Terry stop, but you could also talk about Plainview, but needed a lot of depth on Terry for this particular essay. So on that note, we will go to essay number 2, which is community property. And I think, is that Becky or Kate?
That's me.
Got it.
So this one, we'd of course start with the general presumptions. And then I would suggest here, because they got married and then they separated, but they weren't sure they wanted to end the marriage because they were going to counseling. I would have started, because it did apply to various number of the assets, with an overall IRAC for the marital economic community. And you'd want to explain that that began in 2015 when H and W got married. And then it was really important to point out that it continued to exist even though H and W decided that they were going to go live separately, because they hoped to reconcile. So there was still some hope of reconciliation. They were going to counseling. So the marital economic community was still intact at that point. It ended when they decided that they couldn't reconcile and H filed for dissolution. Okay. So the earnings and accumulations, sorry, my light isn't great here. The earnings and accumulations that occurred after H filed for divorce would be considered separate property, but anything that occurred while they were separated, but still hoping to reconcile, would still be community property. Then we would want to organize. There were 4 calls, so I'd organize by call. And the first call asked about that Acme stock. And we know that H added $3,000 of his post-marital earnings, which were community property, to a premarital savings account that contained $10,000. And that $10,000 would be H's separate property. So it was really important. Oh, is that better? Yeah, sorry, that's better. It was really important there to talk about a commingled bank account. There was a commingled bank account because we had $10,000 of H's separate property, and we had $3,000 of his community property because it was his salary that he earned after the marriage. And we know that he used some of the money in that bank account to purchase the Acme stock. So we'd have to talk about tracing here. And there are 2 ways to trace, and we'd want to talk about both in order to get a passing score on this essay. So there's the exhaustion method and the direct tracing method. And the exhaustion method requires showing that at the time the property, the asset was purchased, all the community property funds in the commingled account had been exhausted. There wasn't anything left. And we were told here that H spent $2,000 on rent and $2,000 on living expenses. So we know that because there were only $3,000. Oh, thank you, Olga. That's very sweet. I love you too. Because there were only $3,000 of, there was only $3,000 in community property and $4,000 of community expenses. The funds, he probably could prove that the community funds had been exhausted by the time he purchased the stock, in which case the stock would be H's separate property. The other method is the direct tracing method, and it requires showing that there were funds available, community separate fund property funds available to purchase the asset, and that the proponent intended to use separate property funds to purchase that asset. And I think you can establish that here. I really, honestly, if you wanted to come to a different conclusion, I think that would have been okay. I don't think that would have killed you, but I think you needed to go through both of the tracing methods in order to get a passing score on this essay. I ultimately concluded he'd probably be able to trace the Acme stock to his separate property. So the Acme stock would be treated as his separate property. Okay, then we've got Winona's post-separation disability insurance payments. When I heard post-separation, I was like, okay, well, they've separated, but they were gonna reconcile, and then they separated for good. So I split this in 2. If disability insurance payments are meant to replace wages, they're going to be treated as community property if they're meant to replace wages during the marriage, and separate property if they're going to replace wages after the community ends, right? And I'm thinking here, we're told that she only gets this money until she's 65. So to me, I'm inferring that this is meant to replace wages because 65 is an age where you can start collecting Social Security. A lot of people retire. So I'm thinking, I'm pretty safe saying that these disability insurance payments are meant as to replace her lost wages due to her disability. So then I thought post separation. So what I said is anything that she got after he moved out, but while they were still intending to reconcile, those would be treated as community property and would be split. Once H filed for dissolution, anything she received after that, that would be her separate property. Okay. Then we got the investment account, and Maureen talked about the importance of using every fact. There were a lot of facts I think you needed to use here. So we're told this was important. He'd already moved out, but they hadn't decided to split yet. They were still hoping to reconcile. So it was important that the money he used to gamble was community property because the marital economic community was still intact. So those winnings would be community property, and what he purchased with the winnings, or what he opened with the winnings, the investment account would be community property. Now, there were a couple of facts here I think you needed to address. One is we were told that he opened the investment account in his name only. That fact is there for a reason. They probably wanted to talk to you about, wanted you to talk about it, about transmutation. Doesn't matter that he opened it in his name only because there wasn't a valid transmutation, because we know that W didn't consent in writing because he didn't tell her about it. The other thing I thought was raised by these facts, because he didn't tell her about the gambling or the investment account because she knew he wasn't thrilled with gambling, was breach of fiduciary duty. So I would have talked about that there. Finally, the loan for the sailboat. It's really clear from the facts that he bought this sailboat to help him cope with the pain of the divorce. So we know he bought it after the marital community ended. So it's a contract debt. Debts are incurred at the time they're made. So he had a contract debt after the marriage ended. So it would typically be his alone unless it's a necessity of life. I don't care what anybody says, a sailboat to help you get over divorce, probably not a necessity of life. So the loan for the sailboat would have been, he'd be his liability alone. Okay, so I don't think this was really all that out of the ordinary. The other one I talk about, we'll talk about, I think was much harder. I do think you needed to talk about both of the tracing. I do think you needed to spend some time talking about when the marital economic community was formed, that it didn't end when he moved out, and establish when it actually ended. But I think they're putting those facts in there about him not telling her because it got at breach of fiduciary duty.
Thanks so much, Kate. And yeah, and we'll take questions at the end. At least Kate and I will. Becky will have to hop off, but we will chat. All right, I think this next one is Becky, right?
It is. So question number 3. And of course, now we are, if you're back on exam day, we're on the final question of the morning portion. And just quickly, I want to say something about time management, because this was back in person and you now had a block of time instead of the online tests that cut you off after each essay. So it was really important that you manage your time. And in some ways, I think this test overall, the exam, really tested the ability. They gave you essays at the beginning of both time periods that had a lot of issues in them. So I know some people on the criminal essay, there was so much to put in there. They really poured everything they had in there, and they might have gone over on time a little bit, and that set them back. So you might have reached essay 3 without perhaps as much time as you had hoped for. And I think there were ways to recover in this essay if that had happened to you by hitting the main issues, but there was also some depth that this essay was looking for, and that's really where the points could grow up into the passing score and even beyond that. So we have Diana and Pedro, and the call of the question is, what claims made Pedro reasonably assert about Diana against Diana? So we have two private parties, and hopefully the facts spoke to you and called out nuisance. We have Pedro, who is complaining of the noise in his home. It's so noisy from these rock concerts that his house is vibrating. So you wanted to definitely raise private nuisance as the main issue there that Pedro is going to assert against Diana. And then there's some depth that you want to do. You definitely, this is one where you really want to break up each of the elements of nuisance into a separate IRAC. So you can talk about whether this is substantial. And some of the facts that go there is we're looking at whether this interference is offensive, is it inconvenient, and is it more than what should be experienced there. So Pedro could feel the floor shake. He couldn't have a normal conversation. But we also have these other facts that this is only on the weekends, that there is a time cutoff. And so you wanted to raise those here to say, is this substantial? And then we're looking at also, is it unreasonable? Here, there was those facts that the other neighbors had maybe complained about it. That makes it sound unreasonable, but also that they had learned to live with it. And again, we have the mitigation measures. It's really important here that you weigh those factors that the court is going to look at. And this is where the depth comes in. So we have these facts about the nuisance for Pedro, that it's loud and that there's vibration. But there's a lot of facts they talk about that what is the impact and the harm if the theater isn't able to have these concerts. So this is a place where you want to add all of those facts in and add the depth to that conversation about the court needs to weigh the injury with the injury for the theater. So bringing all those facts together there. And then, of course, actual possession, Pedro clearly owns the home, so that's a pretty clear element. So I think you could actually probably come down either way. There's a lot more facts, and there's a strength in the argument that Pedro probably couldn't get over that balancing of the hardships and the interests, because it seems like the impact for the theater that employs all of these people, that only has the concerts on the weekend but couldn't operate without them, the court may weigh those as a greater hardship. So you'd want to go definitely through private nuisance. You would want to quickly also touch on public nuisance. The factors are quite similar, but you want to really raise the facts here that say the other neighbors complained, they were not able to succeed, and they learned to live with it. So does Pedro have something that's different than the rest of the community that allows him to bring that public nuisance? So I think if you didn't hit on public nuisance, I think you could still get a passing score, but you could throw it in there as well. And then there was this really, and then for both of them, you want to be raising some of the defenses. So the possible defenses, although they don't mention specific zoning, we know the theater was there first. Diana had been operating the theater for 30 years. And so that gives you some sense that the theater was there, and then they moved the residential neighbors in, and the neighborhood was developed. So raising that, again, it's not a full defense, it's a consideration. So you would want to note that. And then as well, sort of an assumption of the risk of coming to the nuisance. So Pedro purchased the home when the theater was already operating and running these rock concerts. So again, it's not an absolute defense, but it's a defense that can be raised and considered. Again, all of these weaken Pedro's success, but he certainly can bring the nuisance claim. Then we have these really quick and easy facts on trespass to land. I think here they just wanted you to note that intent only has to be to enter the land. She doesn't have to have a bad intent. She was going there to help solve the problem, but that doesn't matter. It's just the intent to enter the land. And it was pretty simple, quick, just throw in the trespass. And the damages, you could go through, I think, a regular trespass breakdown there and say that he doesn't need to demonstrate actual damages, and then it would be appropriate to bring that up as well under the next call and dividing up remedies separately. So if we go on to remedies, there really were, and I think this again for time management, I mean, I talked a little bit about the depth, but you really wanted to divide your time so you had enough time to thoroughly discuss the remedies. There are a lot of points here, and if you didn't have time to get to remedies, it really didn't allow you to write that passing answer. So talking first about legal damages, what compensatory damages could Pedro get? He has his home, so you know, the full value of the home is not a likely damage, but they think you would want to raise the diminution in value of the home. Did the value go down because of the noise and the effect of the theater? And again, possible costs of abatement. So we have these facts that Diana, the reason she was trespassing is she was looking as to whether he had soundproofing. So I think that raises the idea that the court could find that the Diana and the theater need to cover the costs of soundproofing for his home. The big points here for call 2, we're discussing the equitable remedies. So looking at an injunction, both a preliminary injunction to stop it right away while you're waiting for trial, and then the permanent injunction. There's quite, you know, I would walk through each one, divide these up into sub-IRACs if you had time. That certainly would earn more points, and that's where we saw people who get high scores on this to get those points. I think there is a pretty good argument, and again, the balance of hardships going towards both of them, that the court is not going to grant an injunction on this, that the hardships likely favor the theater. And certainly, I don't think there's irreparable harm waiting for trial that would cause a preliminary injunction or a TRO to be granted. But if you had time to mention those and kind of walk through what all of those possibilities were, I think they certainly awarded points for that. And then I think when, you know, some of these balancing are kind of similar. So within the permanent injunction, if you're doing that balancing of hardships, you know, you could have done it really thoroughly in the nuisance and then kind of pulled in it briefly if you didn't remember that or forgot it on that, and you really had it in detail here. I think the important part was that discussion of hardship had to be in this essay in one, if not both places. I think also here you would want to raise that some nominal damages would be available for the trespass, but not likely punitive damages, because again, her intent was going there to try to resolve the problem and to find a solution for that. Maureen or Kate, do you have anything to throw in there?
No, I don't.
I would just add, I think this is one place where you did have to use the facts and recognize that this was a place you could make arguments on both sides. I think they put facts in there purposely, facts that favored Pedro and facts that favored Diana. So I think they were looking for you to present the arguments on both sides. And when you raise counter arguments, if you present arguments on both sides, in order to avoid a contradictory conclusion, you really want to explain why you think one argument is stronger than the other. Otherwise, if you present both arguments and then just say, well, party A has this argument, party B has this argument, party A is going to win, it's contradictory because you've given arguments for both A and B. So you want to make sure you're explaining why you think party A has the stronger argument.
Yeah, and that's something we do talk about quite a bit in our essay course and all of our courses, really, just so you know, just throwing that in there. All right, thanks, Kate, and thanks, Becky. Next, Becky and I are actually both going to cover this beast of an essay. As Becky mentioned earlier, they started you off in each writing block with an absolute racehorse. That crim law one, I'm glad Becky mentioned that. That crim law one was a racehorse. And this one, I mean, this is a 2-pager. they rarely go on to 2 pages. And, and this was a 2-pager, which was just absolutely brutal. I remember people, you know, texting and calling and emailing after this, just saying that it was just an absolute beast. So if you felt that way, you know, it's not surprising. And this really, you know, if you did borrow time at all on this, it was really going to impact, particularly, I think, the PT, because the PT was fairly complex. And I'll talk about that at the end. But let's first walk through this evidence essay. So this was a, you know, the big evidence essay we had. What was it? We, you know, Kate called it the murder pants. With the guy with where there was a prosecutor, there was a an attorney representing a particular client for a murder charge. There was like murder all over this bar exam. And she was initially representing him, then found out that, you know, he had essentially allegedly confessed to a friend, etc. Then there was a pair of bloody pants that she had that she turned over, all of that. So this was an evidence, a California evidence and PR crossover. So I'm going to go through the evidence components, and Becky's going to go through the PR components. So first, there was the questions about Ben's testimony. And so this particular essay really required you to focus really on each question they were asking you, and to just focus on that, which can be difficult sometimes. I saw a lot of people writing about, you know, the fact that, which is asked about in the last part, Anita's testimony regarding B telling her D said he killed Victor in the first call. So you really had to like follow the facts and keep everything straight here, which is a little bit complex. But the first question is Ben's testimony. So you always talk about relevance. You talk about both logical and legal. There were so many issues in here. I didn't list all of them out, you know, one by one. You talk about relevance. You would address logical and legal relevance separately. You could even do strategically, you could even collapse them together here, because there were so many issues in this fact pattern, but you would ideally break them apart. And I did see a number of people do that. And then you would go into the hearsay issue. You go into the hearsay issue because Ben's going to testify as to what D said to Ben. So you could use a couple of different hearsay exceptions here. Sorry, I should say at the outset, we should have talked about Prop 8 right at the outset. This is a criminal case in California, so Prop 8 applies, and then we would apply it throughout. So again, hearsay, statement of a party opponent, statement against interest. You could raise either one of those or both. A great essay would do both. Then do Prop 8, and conclusion is that this would be admissible because you have a hearsay exception. It's absolutely relevant. It goes right to the heart of the crime as to who committed this murder. Prop 8, you know, as most of you know, if anybody is worried about, you know, remembering the distinctions between California and federal evidence, generally, you know, with Prop 8 generally isn't going to make a difference. It's incredibly rare that it would. You just have to address it, you know, here Prop 8. It doesn't, you know, won't impact the hearsay rules here. And so overall, this is going to be admissible. Second question they asked about was Anita's testimony regarding Dan's statement he was with Frank the night of the murder. And you had to really parse out here. This is Anita, the former attorney, testifying in the criminal case. You had to really separate out the PR and the evidence issues. So here you talk about relevance. You didn't necessarily have to, but you could talk about character for truthfulness, but this wouldn't come in because Dan hasn't testified yet. D has not yet testified yet. Here, they haven't done privilege in a while. And here you had to talk about the attorney-client privilege. Talk about attorney-client privilege and whether the crime fraud exception would come in. And it probably wouldn't. The crime fraud exception wouldn't save it here, especially because this is California. California is the most confidential jurisdiction. So, and then you would bring in Prop 8, but the conclusion would be that this was a privileged conversation, so it would be inadmissible. So this particular statement would not come in. Next, we go on to Anita's testimony regarding the bloody pants. Here, it's really, I saw a lot here. This one, I think it was like sort of a little bit of a thinker. Really, you should talk about the relevance. You might want to talk about authenticating it. I saw some people mention even like best evidence rule. But here it's authentication because you have to know she might testify about the bloody pants, but you'd actually need the bloody pants and you need some sort of authenticating evidence to prove whose blood it was on the pants. So you actually needed to talk about those issues a bit here. So this one, I think, threw a lot of people off. It's like, well, you know, what issues do I talk about here? But that's really what I saw was the authentication. Again, raise Prop 8. In conclusion, you could really go either way here. It just depends on your discussion of authentication. There was nothing suggesting that this would be authenticated, but you could say, assuming this was properly authenticated, and they could be, then it could be admissible. So it could kind of go either way there. It just depends on sort of how you set it up. The last point they asked about here was Anita's testimony regarding B telling her D said he killed Victor. Here, there's obviously relevance, but this is a big double hearsay issue. So you have D's statement to B, which is we've already talked about, but again, statement of a party opponent, statement against interest, you could easily refer above there. But you have B's statement to A, there's no exceptions there. So you recognize it as double hearsay. You can say C above, the analysis above, because it's talked about in call A. But for B's statement to A, that was made outside of court, that's hearsay, and there are no exceptions that are available there. So this would be inadmissible. So that would be inadmissible. So a lot to cover here. Efficiency was really key. You know, you had to and one thing I want to say about the evidence component here is with as many issues as there were in the evidence, just in the evidence app, this would be enough if it was just evidence. This would be a racehorse. But now we throw on PR on top of it, and it's just brutal. So you had to really know how to strategically approach this, like when to do a single IRAC for relevance, when to just really get to the heart of the issues. And people that scored high on this did that, and they did it well. So with that, I'll turn it over to Becky, who's going to speak on the PR components to this.
Yeah, and I think part of that efficiency and part of what they were testing here were, I mean, with Anita and her testimony versus her ethical violations, I mean, I think they were really awarding for points for people who distinguished that attorney-client privilege protects from testimony. So you really only wanted to raise that there with Anita's testimony. And then the ethical issue that is raised is confidentiality. So for the first two issues, the turning over the pants and also the email exchange, clearly the duty of confidentiality to the client is key. You definitely needed to raise that, and you needed to discuss that. It really then is weighed against the duty to produce evidence. So there's also this duty, particularly within criminal defense cases, where if you receive evidence that's the instrumentality of the crime, you are required to turn it over. And the idea is that, you know, the defendant can't give his defense attorney the gun to hide so that the police can never find it. So there is some duty to produce evidence. And I think they wanted, and PR loves to test conflicting duties, a duty to the client versus a duty to the court or the profession, and how does the attorney decide between those. I actually saw passing essays come down either way on this. Some said, yep, you've got to turn those pants over. We were sort of joking, Kate and I were like, well, what did he murder the person with the pants? Like, are the pants the murder weapon? They didn't give us a lot of facts about the murder, what kind it was, why were the pants involved? You know, were the pants even really belonging to the defendant? That's not clear. So I think what you wanted to do, you didn't have time to develop all of those, but you wanted to decide one or the other, and then again, explain why you decided that. And if you had a logical reason, then they awarded points. I think the strongest argument is within California, the duty of confidentiality to the client is highly protected. So I think you're safe saying, particularly because the facts don't tell us whether she talked to her client about these pants and determined that they were the murder weapon, or had really any information about whose blood was on the pants, that she had a duty of confidentiality, even though it wasn't her client who gave her, because this conversation happened related to the representation of her client. You could also say, well, she has this important duty of confidentiality, but I think it sounds like this is a really important key piece of evidence that would be required to be turned over to the prosecutor. So I'm going to say that she has that. She's going to need to do that. I think there were really points, if you had time and knew the specific rules about interference with evidence. So, you know, some rules about the attorney not being able to take or retrieve the evidence, that they can be compelled to testify as to an original location. And that really what needed to happen here is that she needed to speak to her client about the pants. Were they his pants? Whose blood was on the pants? How were they involved in the crime, to determine, is this the type of evidence that I have to turn over? So that was the first one. And then we turned to the email, and I think the email is actually easier. I think the email, you could have gotten a passing score just by saying, this violates the duty of confidentiality. She clearly has a duty to her client to maintain the things that the client tells her, and this violated that. Because throughout this answer, we sort of have this repetitive issue of the client lying, or her, sensing that the client is lying. I think you could have quickly raised client perjury and said, if she was continuing representation, she would need to counsel her client that he couldn't perjure himself on the stand. They would need to consider if he would take the stand in his own defense. So that is not something I think you had to pass, but it's something that you could have raised. And then finally, the ethical issues involved in the duty to withdraw. So this was a permissive withdrawal. She decided she wanted to. I don't think there's facts here to support that she had to. He wasn't continuing to commit a crime through her assistance. And so I think that you could have cited that she could have requested the permissive withdrawal. In sort of her own words, she said it was because she was tired of him lying to her, but that could be because the client makes the representation unreasonably difficult. And then she followed the procedure to withdraw, it appears. She requested permission from the judge. The judge granted it. There aren't really clear facts that suggest it was right before trial, and we know that that the defendant was able to get counsel and prepare for trial. So I think you could find that the duty to withdraw was not violated and get the points by just going through what the procedure was. So again, at the end of the essay, hopefully you had turned the page before you thought you were at the end of evidence and had time reserved for professional responsibility. I don't think this PR, because it was with the evidence, required to pass sometimes the depth that's needed. I do think that it required you to recognize the competing interests. So the competing interest of the client's confidentiality and then the duty to produce evidence. And getting through those, again, you probably could come down either way, as long as you had a logical argument as to why you selected that conclusion.
Thanks, Becky. All right, so now we'll move on to essay number 5, which was pretty brutal for a lot of people, it seems. And Kate will handle that one.
Hi, everyone. I do agree. This one was tough. I think a lot of people didn't know what to do, especially with the third call. We'll get to that in just a second, which is on what theory or theories might Arnold be found personally liable to Betty. The key here is when they say theory or theories, I'm thinking they want you to talk about more than one theory. That's likely. So I was looking for more than one theory. So we know Arnold entered into a contract with Landlord Co. before the paint company was incorporated. So that would make Arnold a promoter, and promoters, who are individuals who are acting on behalf of a corporation that has yet to be formed, are personally liable on pre-incorporation contracts unless there has been a novation. And or there's an agreement between the parties that expressly states that the promoter isn't liable. So Arnold entered into the contract with Landlord Co. for this 1-year lease before he incorporated Durable Inc. as a corporation. So he is a promoter. Now, we're told that Durable Paint Inc. agreed to assume all rights and responsibilities for the lease. I didn't think there was an express novation because we're not told that they're releasing Arnold for any liability. I think it's okay if you said that there was, but you would need to address promoter liability. The other thing I thought was raised by the facts here was piercing the corporate veil. right? When we can disregard the fact that this is a corporate entity and get at individuals personally. So there are two things I think you could talk about here where facts matched. The first was ignoring corporate formalities. And I actually think you'd want to dismiss this as an option for piercing the corporate veil, because there are facts here that would suggest that Betty and Arnold observed corporate formalities. We're told that they held a board meeting, they named themselves as directors and officers, they voted for the corporation to assume all rights and liabilities for the lease and to accept the assignment of Arnold's patent rights. So I think that there are facts there that would suggest they didn't ignore corporate formalities. I think where you'd want to spend more time is on undercapitalization. And I think there were a lot of facts here. So firstly, we're told, we know that Betty contributed $100,000. We know that Arnold contributed this patent that he told Betty was worth $100,000, but probably was likely, regardless of what he believed, only worth $50,000, because we're told that other entities had offered him a max of $50,000, other reputable entities. And I always tell students to circle adjectives and adverbs. It's there for a reason. So we can assume that they had $150,000 when the corporation was formed, $150 in corporate assets. Now we're told later that 6 months after the corporation was formed, the patent became essentially worthless because a competitor came up with something. That's irrelevant, because we look at, were there sufficient assets at the time of formation? So it doesn't matter that the patent later became irrelevant. We want to focus on what they had at formation, which looks like $150,000. We're also told that the manufacturing and supply problems that drained the corporation dry were unforeseen, right? Which would suggest that maybe $150,000 at the outset was reasonable, that the corporation wasn't underfunded. So I think it was important to talk about the fact that those expenses weren't foreseen. So I think you would want to raise the arguments on both sides there. If the corporate veil was pierced, then Arnold and Betty would be personally liable. If it wasn't, then they wouldn't. And I don't think it really mattered what side you came down on. I'd seen both arguments, as long as you recognize that there were arguments on both sides. With regard to Betty, she's obviously not a promoter, but I referenced the rules above for piercing the corporate veil. What applied to Arnold would apply to her. Now, if you read, Maureen, is it okay if I share the essay real quick? I have it popped up. Can I share the screen and show the essay? Is that cool?
Yeah. I think
Okay.
you have, I'll stop sharing and then you can share.
Yeah. I just want to show you something, because when I first started this essay, I was like, oh, it's a partnership essay. Hold on, let me find it here. Sorry, guys, if this is good. All right. I thought, oh, this is a partnership essay, because it said Arnold and Betty agreed to launch a business selling a durable paint that Arnold had developed and patented. They agreed to share all profits and to act as equal owners, right? This is reading like this is a partnership. So that's what I thought originally. So I did think, I'm going to stop there, and then you can, Maureen, you can bring it back up. Thank you. I did think you could talk about this as a general partnership and say, well, if they chose not to treat this as a corporation, there obviously meets the requirements for a general partnership. And partners are liable for contracts that are within the scope of the partnership and made with the authority of the partnership. And we're told that Arnold's job was to do everything that needed to be done to form the corporation, and Betty had a particular job. So I thought that was for a reason. I thought you could have talked about, well, this was within the scope of Arnold's authority as a partner. So if this was treated as a partnership, then Betty could be liable for the contract in that way. Okay, next slide, please. Okay, so here's what I thought about Arnold being found personally liable to Betty. Now we know what he did that was naughty, right? He told her that the patent was worth $100,000, even though he knew that he had tried to sell it to other entities, and the most that had been offered to him was $50,000. So again, I thought you could talk about partnership fiduciary duties, the duty of care. You do have a duty to not engage in grossly negligent or reckless conduct or intentional misconduct. But I think the most important things to talk about here were fraud, which is intentional lying, and negligent misrepresentation. Now, you're not told whether Arnold really truly believed that his patent was worth $100,000 and just thought that everybody he tried to sell the patent to was nuts, in which case it couldn't be fraud, because if he honestly believed that the patent was worth $100,000, he neither acted intentionally or with reckless disregard of the truth. But he was at least negligent. There was at least negligent misrepresentation, because representing to Betty that this patent was worth $100,000 when he knew that nobody had offered him more than $50,000, and these people presumably, I think, were told they're reputable, means that he couldn't have reasonably believed that the patent was worth $100,000. So I think you would want to address both fraud and negligent representation. I think either would have been okay, but ideally, I think you'd get points for addressing both. And the main difference there, you could refer to a lot of, you could combine, save some time. A lot of the elements are the same. The key, so you wouldn't have to do the analysis again, but the key difference is the scienter. What mental state do you have to have? Oh, you would not want to write about duty of care, by the way. I saw some people write about duty of care and duty of loyalty here, because we do not have a shareholder suing Arnold as a shareholder. Right? So that would not have been appropriate to write about here. And I think that's where a lot of people went wrong. This is not a situation that, it seems, and also the corporation hadn't been formed at that point. So 2 clues that you wouldn't have, I think that's what a lot of people wrote about, but that's why it wouldn't have been appropriate to write about here.
Also, yeah, Kate, I saw a lot of people talk about direct suit versus derivative suit.
It's not a shareholder suit.
Yeah. Yeah. So yeah, that's something, yeah, I've seen that a lot. So I'm glad.
And I think this is what this call, I don't think the first 2, I don't think were that bad. This is what I think like threw a lot of people for a loop. I'm interested to see if when the bar, because they haven't labeled, have they labeled it yet as BA, straight BA?
They said, I think they did. They said business associations, which
Okay.
is agency partnership corporations. Yeah. Did you think something else?
I
too?
thought, I thought
Well,
I could see it as because I could see the torts. Yeah.
Yeah. No, I think it was just labeled. Yeah, I'd have to double check, but it is, yeah, labeled. Yeah. Oh, BA remedies. Oh, that's interesting. Yeah. I get that. Yeah. All right. Now we will talk about the PT. This one was kind of a beast. So I don't know how many of you found it a little bit challenging. I realized the big key to it about halfway through. But a couple things about it. So it's an objective memo, which a lot of people I'm sure were relieved by. It was really rule heavy, incredibly rule heavy. So that was a big thing. If you have, a lot of people probably had some time management if you're not used to that. So this is a really great PT to, if that's your, if you need to practice that, this is a really great PT for that. Somebody asked, is it common to have only one case of PTs? I don't know if it's going to be common. They have done that a bit recently. Since they switched to the 90 minutes, they do that. Yeah, I think this is the 3rd time they've done that in the 6 or 7. God, how many times is how many 90-minute, how many 2-day exams have we had now, Kate?
Since July 2017, July 18.
Right, but yeah, so how many is that?
20, 21,
Yeah.
10.
10, yeah. So I think at least 3 of them have had just one case. So I don't know about common, but it's not something that you should not expect. Because yeah, there was the Maney one, the Western v. Secure Trade, and this one, not Maney, Davis. Yeah, which was the first one. So I think there's been 3. There could be one more, but I think there's been 3 that just have the one case. So you had to have a really heavy factual discussion, and you really had to make sure that you applied every rule to the fact pattern. and did some analogizing to the case that was in the library. I think it's Nelson. The other big thing that I talked about in the PT course, I don't know if everybody recognized it necessarily, was that you really had to do a reconciliation of disputing facts. They changed the PT instructions for this bar. They changed the instructions for this bar. That made a big difference. So they said in it, now the instructions say something about, you may see disputing facts. If you see disputing facts, you need to recognize that, or conflicting facts. I forget the exact language. And if you recognize that, you need to say how we need to deal with it. That was absolutely present here. Previously, they would actually say that in the task memo. They would say, if you see, there are conflicting facts, if you see conflicting facts, please identify it and talk about how we need to address, what do we need, what information do we need to obtain to resolve that? And there was a big dispute here. So this is the sort of overall structure. I'm not going to get into like the ins and outs and all the depth of this particular PT. I'm not going to, because it takes like an hour and a half to like break down a PT to go through it. But overview, and I will go through this in our PT course. Like, this is something that we actually really will go over, because I want to talk about this. But this is how I would have organized it. The introduction, you would have had your, introduction below. Please find my analysis regarding whether Price violated Rule 4.2 in the October 3rd conversation, whether he violated Rule 4.2 in the November 8th conversation, and whether Rule 5.2 can serve as a defense in either conversation. So this is what I would have done. So you obviously have to use it, Nelson. I would have had a section for the October 3rd conversation. This was pre-indictment, so it was not a violation of Rule 4.2. So it was pre-indictment. Nelson makes that clear. However, it could be viewed as being a little bit iffy. It could be viewed as saying, well, he really shouldn't have done that, because it was he's the criminal defendant is represented by counsel. It's very clear that the attorney does not want the defendant speaking to Price or any of Price's agents. So you could say, maybe, an incredibly strict reading of this would find that there was a violation. But even if that were the case, 5.2 would save Price here. It would save Price here, because Price did go to his supervising attorney, Layla. He went and spoke with Layla, and Layla said, you can just listen, gave Price this advice. And Layla does confirm that. However, Layla gives some instructions, but there is a factual dispute here. There is a factual dispute regarding whether Layla referred this out to actually talk. Did Price actually talk about 4.2 with Layla or not? Because she says, had he brought that up, I would have referred it out. This is not a minor issue. Speaking with, a represented party is not a small issue. So there was a big factual dispute in there in each of their testimonies, in each of their transcripts. So that was a really big deal. There was a big factual dispute. And what you needed to do was say, you need to go and you need to talk to, I think his name was Lamar. You needed to talk to Lamar and interview Lamar to say, did you have a conversation with Layla about Rule 4.2 with respect to the how matter, with respect to this criminal defendant? Conclusion here, though, and I saw a lot of people conclude that this was a violation. I don't think that there was a violation here, though. And I saw a lot of people really not dealing with that factual dispute. That's where I think a lot of people that were really disappointed with their scores, they did a nice rule proof of Nelson, broke things down. So there was a couple of things that I saw that were missing. One, really not dealing with that factual dispute. That was a big deal in this particular PT. There was a lot of emphasis on it in Layla's transcript. So you really needed to deal with that. You really needed to talk about how 5.2, even if it was a violation, giving an alternate even if it was a violation of 4.2, providing that alternate argument to say that 5.2 would actually save Price here. So this was the first issue. There was a lot of discussion. Kate, did you have something or no? Oh, okay. Sorry. It looked like you wanted me to pause. Second issue was, whether Price violated Rule 4.2 in the November 18th conversation. in between the October 3rd, I think it was on October 19th, in between the October 3rd and the November 18th conversations, the defendant was indicted. So after this point, it is incredibly clear that post indictment, you cannot, a prosecutor may not speak with a represented party. They may not speak with a represented party, and it is their, so you cannot do this. You had to analyze Rule 4.2. You had to bring in Nelson, talk about that. Every argument that was raised in Nelson, you needed to also raise here, so that it was just an investigation, that you were just listening, etc. You needed to raise those here, dismiss those arguments. They would absolutely fail. They would absolutely fail. And then talk about how 5.2 cannot save Price, how 5.2 cannot, because it's not a close call. Nelson is very clear on the issues here. So this particular PT, I saw a lot of people organizing it, just doing the October 3rd conversation and then the November 18th, and then doing a whole thing about 5.2 at the end. I don't think that worked very well. You really had to say, okay, it was this conversation, and 5.2 is a defense to 4.2. So you needed to talk about them in conjunction. So you needed to talk about each rule within each discussion of the particular conversations. So this PT was, they really did challenge you with that fact reconciliation. They put that instruction in there and wanted people to hit it. It wasn't expressly called out in the task memo. So now this is something anybody going forward needs to be on the lookout for, and you needed to reconcile the factual dispute here. You needed to reconcile the factual dispute here. So that's what I have to say about this particular PT. Yeah, it was a bit of a beast. And until you figured out that factual dispute and how to reconcile it, you have to say there's a dispute here. Then you have to say, how are you going to resolve it? How are you going to resolve it? And here you needed to be able to say, okay, well, you know, often when this happens, you think about your discovery rules and you bring a little Civ Pro into it. But here it's internal in the office. You just need to go interview the other person. So it's pretty simple here, pretty straightforward, but you had to recognize that issue. And I didn't, and for PTs that I've looked at that didn't get high scores, didn't deal with that particular issue. So that change in the instructions was pretty significant for the bar, and it should be something that you're absolutely looking for going forward. And it's something you should practice doing, but you know, looking for PTs where that is assigned, so it's called out. But we can, you know, I always give people those, you know, in the courses, I always say, all right, here's a few PTs that make you look for this. The selected answers are not yet up on the bar website. We figured this out, Kate, Becky, and I, by chatting, you know, among us. Really, they chatted a lot. And also by us going through and, you know, looking at, you know, we've consulted with tons of people recently. We get, you know, we get essays, we get fact patterns, etc. So we look at those as well, so that we can do this and you know, but we always start going through it before results come out to get an idea, and then things are confirmed from there. So now we will open it up for questions. I know that there were, I should delete that. We're going to do an MBE workshop. I don't know if it's going to be next Thursday, but we'll send out an email about that. So let me go back up to, there was a couple of questions. First, Catherine, you said, so with respect to your question about the MBE, I don't actually want to talk about that one like here, but we can, because I think there's actually like, that's an interpretation of it. And that's like gets into like a whole other debate that is just something that's like kind of outside the scope of this. But you know, happy to chat about that offline. Somebody asked about the comments of the attorney's exam versus the general exam. Humphrey, we'll talk to you about that in your score review, but just generally speaking, those people that are taking the attorney exam, so you're barred in another state, you've been practicing for, I think it's 5 years, and then you can take just the attorney exam in California. I generally still say to take just the attorney exam unless you're really, really good at the MBEs. And if you are and know that, then great. But generally the MBEs are a bit tougher.
And I'll say that the MBE, sorry, Maureen, that requires you know the law really well. The MBE is the place to test the exception to the exception. So, you know, some people are just really strong multiple choice test takers, and that's a benefit to them. But realize it's I think you need to know the rules better for the MBE than you
Oh.
can't outright. You can't pick up points by the MBE by explaining what your thought process was. You can sometimes on the essay.
And you also can't make up for, generally, you can get like, I've seen people get scores in the high 1500s on the MBE and still not pass the bar because the writing isn't where it needs to be. So like, you still have to really push that writing up to where it needs to be. So, maybe it'll give you like a 50-point cushion, but it's usually the time it takes to prep for the MBE to get a high score is not going to be enough to offset just the written. But I have seen people that, that do it. And sometimes it's like, I don't think it's that the MBE score is so high. I think it's just like learning the law, the level of depth for the MBE carries people on the writing. And that actually is kind of what makes the difference. But that's something we can also talk about people individually. Yeah. So, and then we will take, if people want to raise, click raise hand and ask a question. Lavinia, if you have a score review scheduled, we can look at your PT in particular and talk about that. I don't think I'm doing a separate Zoom just on the PT. That's like part of a free workshop, just because I don't think I have time. I have like workshops that I'm teaching like literally almost every night for like the next 2.5 months. So yeah. Eileen, we have outlines of the answers. It takes us a lot of time. But we do, for every answer that we write, like in our courses, we always write answers out that are, we always do. So in all of our courses, whenever we give you an essay, we are going to give you like a full written answer to it. So we do that. We haven't written out full answers for all of these essays. I've like basically done the PT, but yeah, it's not done. And sometimes it takes me a little while to get to finishing that. Oh, thanks, Rose. I'm glad to hear that. Gabriella, we're going to talk about MBEs in the next workshop that we do. Kate and I are going to be hosting a workshop, and if Becky wants to join, she can join too. Feel free, Becky. But Kate and I were talking about doing it. Kate is a legit like MBE wizard, is what I always tell people. Like, she's so good at them. But that's something we're going to do, like a whole workshop on that. So somebody sent me a DM saying, if asking me to go over the courses we offer and what you should look at when selecting a course. Yeah, sure. We have a whole variety of courses. So I'll go over some of the workshop courses and then some of the full courses. Well, actually, no, I'll do them in reverse. We have full courses covering everything you need to prep for the bar. So, we have essays. It's like, your outlines, the substantive materials, a daily schedule, all the MBEs, the essays, PTs, all of that stuff we have in full courses, and there's varieties. With those, it just depends on, how much one-on-one attention you want. We have a light course that's really designed for the self-studier, where you get access to everything. You get the live workshops, all of that. We have our classic course, which is what most people do. You get 10 graded assignments. You get 3 one-on-one sessions that are, where it's one-on-one via Zoom with your assigned faculty member or tutor. And then we have Extreme, which has everything else, but you have a lot more grading and you have a lot of tutoring one-on-one. We also have things you can do a la carte. So we have an essays course, Mastering the California Essays, where we cover, I think it's like 8 or 9 workshops, and we cover every single subject tested on the bar. We give you a big picture overview, and then we break down several essays with you. We break down at least 2 essays in every subject. And we go give you, talk about issue spotting, talk about how would you attack it strategically when it's a racehorse. What would, how do you write analysis? How do you write clean rules? How do you, using every fact, where you should use each fact, et cetera. In those classes, we are often having you DM us. So I'll have people write some analysis. I'll have you write counter argument. I'll have you make up a rule, and I'll have you send that to, we will have you send that to us. We will have you send that to us in a DM in class, and we'll give you live feedback on the spot. So people generally love that. The PT course, I teach all of those. The essays course, me, Kate, and Becky, which is why they're all, we're all here. We all teach that class together. But the PT course I teach, and it's 5 classes, and all of the classes, essays and PTs, are about 3 hours. The first class, I go over really in depth the approach to take. The second class, I cover objective PTs. And I also talk about really like extracting rules, drafting rule proofs. The third class, I talk about persuasive PTs. There, I'm getting into really like persuasive writing a bit more, drafting counter arguments. Then we do a fourth class, which is on like all those other tasks. So like closing arguments, weird stuff they can throw at you, like a case planning memo or a will. So, the weird tasks. And then we do this class on PT drills where we have you, like, I give you just a short period of time and you have to like figure it out. You have to figure out what they want, what's the organization, what cases are you using where, it's a lot of fun. And I actually started teaching the PT drills early on so that you can practice like building your skills, like figuring out a PT as you go. You also get access to tons and tons of PTs to practice. If you're like, I want to see this, I'm like, okay, do this PT, and you have access to it, etc. Plus a bunch of answers, all of that stuff. We also, I'm going to do a special thing for grading PTs, which I'll announce in the PT course. It'll be available to them too. So we have a PT course, the essay course. Those courses are each $4.99, and you can split it up into a couple of payments. We also have something called SARX. Well, actually, let me tell you, we have one-on-one tutoring. I do a lot of the tutoring. Kate and Becky does a lot of the tutoring. We also have Tina Schindler is doing tutoring for us as well. A lot of you use that, like, people call it the Mary Basic book that on essays, but she wrote it with Tina. Tina is also doing some tutoring for us. I do tons and tons of MBE tutoring. Like that's largely when I do tutoring, it's because people need assistance with the MBE. And I like actually go through your data. I do anyways. But I do a lot of one-on-one tutoring for the MBE. So like, that's kind of unique with us is we can do like MBE and essay and PT, like all of it. Like I can switch and do all three in a single session. The sessions are 45 minutes. To give you an idea on price, for like 10 sessions, it's $15.49. And Noelle posted the link there if you guys want to have a look at it. We also have grading. Our grading, I'll just be like upfront. Our grading is a little bit more expensive than I think a lot of other places, but it's really detailed and in depth. We spend on average, we spend about an hour grading. We go line by line. We go line by line and go through it. We look at your rules. We look at your rules. We look at your analysis. We look at your issue spotting, everything. So we go incredibly in depth. And then we also have something called SARX, which I'm going to show you all because I'm really excited about it. It's like, this was like my baby. Well, all of it kind of is, I'll say. But SARX, California. Okay, let me do a new share. So we have this. It's called SARX. So it's $1.99. And what it is we have all the past California bar essays, and these go back to further than what you can find online. We have some going back to like the 80s, which is good just for getting different issues, But so all of the essays, we have like, these are the agency questions. These are all the civil procedure questions. These are community property. But not only that, if you click on Civ Pro, then I don't know why it's going down here. We have to talk to our guy about that. But all of the categories are listed here. So if you want to do a question that tests on PJ, SMJ venue, you click on that and it shows you all of the essays that ask those questions. If you want to look at one of the tests on joinder, you click on joinder. Here's all the questions that ask about joinder. So it's helpful in a lot of ways because, and we have this for all of the subjects. And then we also have a section for crossovers. Plus we have PTs done this way, where you can look at all the PTs categorized by, is it a memo? Is it a letter to a client? What type of PT is it? But you can make sure that, you're not just grabbing random Civ Pro essays, you're making sure that you hit all of the categories that they really test people on. So using judgments, collateral estoppel, res judicata, trial issues, pleadings issues, all of that. So this is a really great way to see, how you're doing. The other thing that's great is that in it, you have the fact pattern in here, you have the selected answers, but we've also give you an issue checklist that says, what are the issues you had to hit at a minimum, just hit to pass. We don't talk about the depth and all of that, but we tell you the issues. Somebody asked if I give predictions. I don't do predictions. I hate them because of my own personal experience with them when I was in your shoes. But we do like a final forecast where I cover every single subject. I cover every single subject in it. And this is part of the essays course, and we invite everybody in the PT course to come to this particular class as well, even though it's for the essays, where I go through every single subject, and I'm like, this issue hasn't come up recently. This issue hasn't come up recently. So we go through through every single subject. And then we also put together a packet of essays that test those issues that haven't come up in a while. So like I was hitting, homicide and a few other things. Like a lot of us think that we thought con law is coming, especially free speech didn't come, but because they haven't done a free speech essay in a while. So yeah. So that's kind of an overview of the courses that we offer. Looking at, I'm going to go through the rest of the questions.
I'm answering some of these just back by DM so I can do it in order. But a couple of things I wanted to highlight for people. One was just a question about sort of, I think the question was a high MBE score in practice, and then freezing when I write essays. So, I mean, in addition to making sure that you're using materials or a bar prep program that's going to prepare you for the essays, so outlines that are essay focused, the ability to learn how to approach and issue spot a lot of the points. We mentioned that 2 to 3 minutes the graders are spending. So issue spotting is so important. So making sure that you're using a program that's going to teach you how to do that and how to prioritize issues. And then my final thing, anyone who's ever heard me teach a class talks about is making sure that you're practicing in exam conditions. So making sure that you are writing and practicing essays in a closed book setting, in a timed setting, so that you're getting a realistic picture of what you can do on the exam. And then you've been practicing that horrible feeling when you open up and you read the essay and you're like, I'm not sure what they want. The more you practice that, the more you learn to get comfortable with that and then attack it in an organized way, the less you're going to have those frozen moments because you've done it so many times. So actually, even though it feels uncomfortable, closing all your notes, reading the essay and attempting it, spending 60 minutes doing the best you can, and then going back and self-assessing, evaluating all of those things. But that's really important. That's one of the things we really teach and work on, is to give you the tools so you can practice in exam conditions.
And I think someone asked, what does it mean when your score is high on the MBEs when practicing, but you score much lower on the exam? So with that, I'd have a couple of questions. One is, how many are you doing? Like, what's your block, right? Because you can get really tired. When I look at somebody, I always look at patterns. Are you starting really strong, but then getting tired towards the end? Or are you starting off weaker and then getting stronger towards, or vice versa, because that's different problems. What sources of questions are you practicing with, right? How are you practicing? Are you practicing on a screen and then sitting down? So, that's something during a score review session, you could talk one-on-one, because I think there's a lot of reasons why, in addition to just performance anxiety, why you could be performing better in practice than you are on the actual exam.
And on that note as well, the other thing that I would say too is like figuring out, like, have you seen the same questions? And if you have, like, I had somebody that I worked with recently that had taken the exam more than 15 times. On Adaptabar, she knew every single question. Her performance was over 90% accurate because she'd memorized everything. And that can be a problem if you've taken the exam a few times. You've seen these questions. So we had to take a different approach with her, and she passed, like, thank God. And because she had that, mismatch. So it depends on the particular issue that you're dealing with. But we also do address, like, that's something that we do a lot of, like, MBE tutoring on, is looking at what exactly is going on with you. Sometimes, like, it's hard for you to diagnose that. And what Kate and I will talk about this stuff in our workshop that we do. Like, I don't want to say, like, you don't just need to, like, do tutoring. Like we'll talk about these in the workshop and we'll go in depth on this stuff, but there are different things you can do. Like you need to, it's okay. Like if you've memorized the questions, you need to write out the answer explanations. You need to explain why is A correct, why is B correct, why is C, or why is A correct, B and C and D incorrect. And you need to be able to write those answers out in full and get them right on your own before you look at the answers and the answer explanations. Like, can you write it out? This is incorrect because it misstates the law because of this, because this is the law for X and here it's testing Y. Like you need to really be able to go and do that in depth. And if you can't do that, you don't actually know that point that they're testing well enough. Because, so many MBEs are testing you on 4 points of law or, different things, right, Kate?
Yeah, and you also need to know why you're getting questions wrong. And I think we'll talk about this, but I think there are 3 primary questions wrong, and you need to know why you're getting certain types of questions wrong. It can be you're getting one category of questions wrong because you just really don't know the law for contracts. I'm just making something up. But it could be that with torts questions, you know the rules really well, but you're just struggling with issue spotting. You're thinking it's testing one element of negligence, but it's testing another, right? So because the strategies to overcome the problem is going to be dependent on what the problem is. So I think the first step is diagnosing, like, okay, well, what's the issue? So then you can work on remedying it, because there's going to be different remedies depending on what the issue is.
Yeah, absolutely. Yeah. And yeah, I mean, I could talk about this stuff forever, but this is also, yeah, I mean, I could talk about this stuff forever, but this is also what we go, like sometimes like in, sometimes what it is too, is like Kate said with the issue spotting, and how do you figure that out? So like oftentimes what I'm doing like is I'm going and I'm actually looking at the questions that people are doing. I'm looking at what you miss, and I'm looking at, okay, you tend to pick equal protection when it's actually like a substantive due process issue. And like, what do they do? Like those patterns. So we look for those patterns. We also often look at, like in Civ Pro questions, they're often going to throw the same 3 or 4 different motions together at you. So it's looking at that and like showing you, demonstrating that stuff with you. So you need to really look at not just, okay, why is this answer right? But you need to look at what's with the other 3. How do they test these things? How do they test them together? So yeah. Lucine's question, one of the same essay. I think people, they might say the same issue a little bit differently. I like largely, I mean, I haven't looked at what anybody else has said, because like I just stay away from other bar companies, like, materials. Generally the way that we know what they're looking for is like, we did look through a bunch of the essays when we're going through these. Like we do look at a bunch of applicant essays, high scoring, etc. Generally, the way that you do that once the selected answers are posted is you take the 2 essays that are released and you look at where are the similarities. What did both essays have? And that's generally what they were looking for. So that's how we check that. I generally check that stuff like once the selected answers are released, but we don't want you guys to wait 3 or 4 weeks after you get results and when you're already into studying to like be able to review the prior exam. Yeah. And I don't necessarily believe at all that if you get a 70 on the PT, like that you can pass with a 55 or 60. Like that is not true. If you get 55s across the board, that's not going to make, like, the single 70 on a PT is not going to make up for it when you have to get a nearly 63 on each.
And do you want to bank on that? I mean, do you
don't
want to
wanna
be,
bank
yeah,
on
you
that
don't want to bank on that.
at all.
That's a really risky move, right?
It's super risky. It's super, super risky. Kate, do you want to answer that last question? How the written scale is based on the MBE? I don't know. I mean, I don't know if I want to actually get into the like how that's actually done. Like I'm not a psychometrician that can explain that really well in depth. Yeah.
There was 2 things I wanted to answer too. I mean, one of the things with the issues that we went through is one of the reasons released answers are really helpful is because of what Maureen said, because you can go through both and see which issues both of them had and sort of narrow that down. But I mean, what we went through is more thorough than what you had probably to just get a 65. But that's also why I like released answers, because they're a little bit more realistic. They're very impressive often, but they're also, they may both have different issues in them and still be a released answer. So I think that what's encouraging about that is you don't have to write the perfect answer, but you need to be getting the majority of the issues. You need to be getting the depth in some of those areas. And then I think that that looking at where those two answers have similarities is really then where you get to those passing answers. But you know, you don't always have to have every single thing that every single you know, issue that we discussed.
Somebody just asked, when do they release selected answers? Sometime in the next 4 weeks. Sometime in the next 4 weeks, we can expect them. And it takes them a while, and it's really disappointing, but it takes a while. Lavinia, I can't really say how can you get an answer at 80. It's going through, it's a depth, it's addressing the correct counter arguments, using all the relevant facts, etc. So generally the answers that I write or that we write for the PT course, I would say is probably going to get you, 75, 80, somewhere around there. All right. Thanks, Lavinia. Did I miss any questions? Mark, sorry, my dog is, Kate, can you answer that one, or Becky, for Mark?
Yeah, so it's tough, but what they do is what will happen is it's not like you'll get a grader who's going to grade all 6 of your essays, right? They have grading teams that are assigned, and you're responsible for one essay. And the way it works is they will meet, they will get the essay, they will go home. Correct me if I miss anything or miss a step here, Maureen. They will go home, they will write out the answer. It's all people who have passed the exam. They're licensed attorneys in California. They're invited by the bar to come be graders. They'll write it, then they will get together and they will, as a group, review several essays and score them. Though it's called calibration. So that's something that, and they'll go through several rounds of that. So it's not the case that something Maureen is scoring a 70, I think is a 45, right? So they're making sure they're consistent, and they're thinking, okay, well, this is what I think, a 55 would do. This is what I think a 60 would do. So they do a lot of work with the essays and a lot of work with calibrating before they take the actual essays, and they take it and they grade on their own.
And I will just add to that. They can read it in 2 to 3 minutes. They can read it in 2 to 3 minutes because that essay cold inside and out.
Yeah, it's the only one they do.
It's the only one they do. Like, I know exactly what I'm looking for. I know exactly where I'm looking for it. I know the counter arguments. I've written it inside and out. All of that. Like, I mean, all of, Kate, Becky, and we all know these essays pretty well because we've all just gone through them. We've, gone through, talked about them, etc. So that's how, like, you know what you're looking for. Where, what facts, should be, and where you're looking for the headings, all of that stuff. Like that essay cold. The bar graders also, generally anybody that's an official bar grader has been grading bar essays, from what I have heard, for about 10 years. People like, you come on, you're probationary or like a backup grader for a number of years. Also, the people that are invited to do it, or people apply for it, they had to have passed the bar on either their first or second try. Yeah, I don't know. I mean, although it sounds like a miserable thing to do to me.
It's not well paid, I can tell you.
And it's horribly paid. So, like, I can't imagine that they're the happiest people in the world doing this. Like, and you have to keep that in mind too. Like, Lord, trust me. I mean, I'm in the middle of grading some stuff right now too. And it's just like, oh, it's the last thing I want to do. And if the stuff isn't exactly where I want to see it, how I want to see it, like, I'm not a happy camper.
They're probably doing it at night after working a full-time job too.
Yeah. So you have to keep all that stuff in mind. Like, your job is to keep the grader happy, like give them what they want. And we talk about this in class, but you want to be like, what's the most ubiquitous car on the road, right? California is probably like a Prius, right? Like, you see them everywhere. It's fine. Well, I won't say it looks good, but no offense. Prius owners say that, but it blends in, it looks good. It's like, all right, this looks like everything else. It's exactly what I'm supposed to see. And we're good to go. That's really what you want to be like, unless you're going to be a Ferrari, don't stray. Lavinia, I don't know what you're referring to exactly. I don't do like a session for foreign attorneys particularly, but maybe you can send me an email about that, about what you're asking about. We do have a lot of foreign lawyers, and I did have a program at California Western. I haven't done that for a little bit though, because I moved out of California. Yeah, so, but I have actually created courses just for LLM students as well. And always when I'm teaching like the PT or the essay, particularly the PT, I focus on, I think I actually know what you're referring to. It's something on Facebook that somebody else has a podcast for foreign lawyers. But that's not me though. I just saw somebody else post about it. Yeah, that's not me. But I do always mention, you know, like if you're a foreign, because I've had like one of my really good friends, I was her mentor in law school. She was, you know, English was her like fourth or fifth language. And she had trouble on the bar, and like she needed words to use in her PT. Sorry about my dog. He's just being a little high maintenance tonight. So yeah, so I do, for any of you foreign lawyers, that's something that I do that like I'm happy to answer and talk about like in the sessions too. I will, Fabiola, I'll let you all know. Yeah, I think you're right, Kate. I think you're right. I saw it on the listserv a while back.
I just want to go back to the 2 or 3 minutes too, to say that that's why organization is so important, because I mean, I do it when I'm grading too. Somebody's going through, you know, the elements of negligence, and they put them out of order. And before I've even seen that they included it, I've deducted points, because I thought in my mind, I'm going duty, breach, causation, and damages. And under duty, I'm, you know, having these things in order. And so something's out of order, I've already deducted the points, and then I see it and then I'm like, oh, it's here, it's out of order. Because I'm grading for an hour, tell them, you know, you had this, but this is where you needed it to go. But the bar grader, like, they've moved on already. Those points were deducted. So organization and buzzwords are really important. And when they see those, then they have time to look for that depth. You know, you think, well, how can they do both? But if they're just scanning through and seeing, but they know where to zone in and look at, did you get that depth here? Did you talk about that? Do you have these facts in here? They can do that when it's well organized and they're seeing that the headings are there and the issues are there.
And also, I can just tell you from working at law schools, like working with bar takers and working with law schools for the last decade, when I get a paper and it's a big block of text, I cringe, because yes, I'm going to read it because, you know, but I'm inwardly thinking, this, you have made my job harder. Like, you want to make, like Maureen said, you want to be that Prius. You want to make their job as easy as possible. You don't want them to cringe when they open your paper because there's no headings. It's in big blocks. You're not breaking up your paragraphs.
And you also like, you want to gain their trust at the outset. And if you, oh no, I'm good. You want to gain the grader's trust at the outset, like lead with good organization, then they're going to trust you that like they can just look at it quickly. If it's not done well, and this is all, and I'm going to give a caveat to this, but that, you know, that you're going to lose their trust, and they're also going to be like, and they're going to be irritated. Like I see that, like I'm like Kate, like being in law schools and like also in undergrad, like where I teach this stuff, like if people don't do it, if people don't give me what I want, how I want it, I get really irritated and I put it to the back of the pile. And then at the back of the pile, it's just all the bad stuff. I'm like, I don't want to look at this. I'm just like, I'll deal with it later. Like I do the same thing. Kate does too, right? A former colleague of ours taught me that. She's like, I'll just put it at the end. But then you're in a real bad mood. But yeah, so get your graders trust, because then if you're bad, like in the middle, they already trust you. And so it's a little bit easier. That's why we often see scores. That's why we often see scores. Like if you go to a second read, which you never, ever want to do, we see scores drop typically. The caveat to that though, is like you organizing well can also make it obvious if you don't know what you're doing, because you can have great headings, but then it makes it okay, they spotted the issues, but if your analysis isn't there, then it's going to be really patently obvious. So you can't hide bad and you can't, it's not just about organizing well. That's like the baseline. That's the baseline. You have to do that, and then you have to like ratchet up like that. You can spot the issues and you know, organize well and get a 55, And if you have to then, like ratchet up to a 60 by like going in depth, and then go to 65 by going even more in depth, writing the counter argument, and like all of this stuff we teach you. And it really does require a lot of like hands-on actual essays going through and all of that too. So I do think bar essays is great. Somebody's asked me that. I do think that it's good. For me, I used bar essays when I studied for the bar, and because my law school gifted it to everybody. And I liked it really to like make myself feel better when I would write an essay and think that I failed everything, because I always like everything I wrote, I was just like, oh, I failed this, I failed that, I failed this. And because I'm really, really, really hard on myself. But that's also like a self-assessment skill is something we focus on in teaching, because we want to teach you how to do that. Because even if people can't grade everything in the level of depth that we do and like grade every single thing you write. You have to be a good self-assessor. So that's something we teach you. But it was just, I use bar essays to look at like, all right, like I wrote this and I think I failed it. Let me look at like what some other people got like a 60, or like they were borderline 65 or whatever. Or sometimes I would like, if I was feeling really bad, I would look at like a low score to just be like, okay, I can at least do that. So you get a second read if your score is, if you get a 13, below a 1390, but above a 1350 after a first read. Yeah.
And I would say the reason, I mean, it's not always bad, but we often see scores, not always, but they can go down. They're different. They're often different. So you can see discrepancies, often 5 points, sometimes 10. I've seen a 15-point discrepancy. So if you think about that discrepancy, that could be what Maureen just explained. One grader went through really quickly, saw the issues, but didn't really go, and that person was on the line. The second grader looks more carefully. They could have a different opinion, right, Maureen? Like,
yeah, absolutely. And it is a different grader. It's a
different grader. Yeah, different grader reading it. Not reads the second grade. And so you end up, and they take the average of that. So if one gives you a 55 and the other gives you a 60, great, now you have a 57.5. But if you had a 65 and then the other grader gives you a 55, now you're lowering your grade to a 60.
Yeah. And you just don't, that means like somebody's looking at it closer. That's when you get more than a 2 or 3 minute read, and they're going to see, oh, they don't really know the law. They didn't really use the facts. They didn't hit this issue. They didn't hit that issue. Like they're looking at, I mean, I feel like they're probably looking at them with a more skeptical eye. But yeah, so, and like bar graders do want you to get, like, they don't want to give you a low score, right? Like, I mean, allegedly, I can't say for sure. But yeah. They don't want to give you a low score. So it's a really hard question to answer, Fabiola. The average length, generally a lot of passing answers that I see are like at least above 1,000 words, usually around 1,200. Sometimes I see really long essays, and like bar graders actually don't want to read that. But the selected answers tend to be around 22 to 2,400 words. I've seen essays that are 800 words get an 80. And I've seen plenty of essays that are like 1,200 words that are like strong, get a passing answer. It depends on the essay, etc. But yeah, like I don't usually like to see, if I see somebody that's right, that like all their essays, like I saw somebody today, most of their essays were around 600 words. Like you just can't, unless you're a really concise, incredibly clean writer, which like I can do that because I worked on that for years. And members of my team are like that. However, that takes a lot of practice, and it's not something that I think that is super common. So I don't know how many times people are like getting in everything they need to get in, 600 words. So usually people are just not hitting all the issues, and they're running out of time. So yeah. Yeah, I'm not sure, Lucine.
I have seen some of the old essay answers are incredible that way. Like I remember one very specifically that was like, it was not that many words, but it was just, as Maureen said, just so everything was done in there. I was like, I can't believe they got it all in. But more and more, it seems like they release answers that tend to be more lengthy.
Yeah. And the last thing I'll say is like, it also depends on who's in charge of the bar. Sometimes they pick the highest scoring answer, the 2 highest scoring answers. Sometimes they pick ones that were like good, but not the highest scoring answer. So like there's so many variables in that. All right, everybody, I wanted to keep this to 90 minutes. We've gone a little over that, but thank you all so much for coming. I think we've got 2 questions. If you haven't scheduled, a score review or anything, make sure you do that. And if y'all have any other questions, please feel free to reach out. Thank you.